All right, so I see that we just went live on YouTube as well. So I'll go ahead and get started as people are being led into the Zoom chat here. Welcome to the Federalist Society's second event of the spring semester. We're so glad that each and every one of you were able to join. Tonight, I think that we're in for a real treat. We have an originalist versus originalist debate on the meaning of the 14th Amendment. And we have two bright young constitutional scholars with us here today. So I'm going to go ahead and introduce them both. I'll start with Evan Bernick. Evan Bernick is a visiting professor of law at the Georgetown University Law Center and the executive director of the Georgetown Center for the Constitution. He joined the center in August 2020 after serving as a law clerk to Judge Diane Sykes of the United States Court of Appeals for the Seventh Circuit. From April 2017 to April 19, he was a visiting lecturer at Georgetown and a resident fellow of the Center for the Constitution. His scholarship focuses on constitutional and administrative law. He has published with the Georgetown Law Journal, the Notre Dame Law Review, the William and Mary Law Review, and the George Mason Law Review, along with many other journals. He received his JD from the University of Chicago Law School, and I believe that he has a book forthcoming. When was that, Evan?
Presumptively August-ish, but under the circumstances, there may be some give and take in that.
So sometime this year on this topic.
Right, exactly. The book is co-authored with Professor Randy Barnett, with whom I work, and it's called The Original 14th Amendment, Its Letter and Spirit.
Awesome. Cool. And moving on to our other panelists for the evening, Ilan Werman should be a familiar face to Texas Fed Talk by now. He is an associate professor at Arizona State University, where he teaches administrative law and constitutional law. He is, importantly, for this evening, the author of the book, The Second Founding, an introduction to the 14th Amendment, which he's waving around, and I'll just go ahead and confess that I have on my bookshelf as well. So it's a good read. I would recommend it to each of you. I know that many of you, especially our 1Ls, have been graced with knowledge from his first book, which is entitled A Debt Against the Living, An Introduction to Originalism. So we have two experts with us tonight. I'm not going to talk anymore. I'm going to go ahead and turn it over to Ilan, who will start us off. Thank you so much.
Great, Seth, and thank you, Seth, and to the Texas Federalist Society for having me back. I wish it were in person, don't we all? But I'm glad, nevertheless, to have the opportunity to talk a little bit about the 14th Amendment and why I think almost all other originalists are wrong about it. And so, and of course, the talk is based on my forthcoming book, The Second Founding, which was mentioned. The overarching claim of the book is that the central provisions of the 14th Amendment, namely, at least its first section, due process of law, equal protection of the laws, and the privileges and immunities of citizenship, are not broad and open-ended invitations, right, for judges to sort of import their modern-day extra-textual values into the text, but neither does the text of the 14th Amendment narrowly confine us to what its framers would have thought about, specific problems in 1866 or 1868. The 14th Amendment, in other words, is not nearly as broad as you may have been led to believe, but neither is it so narrow. Now, in coming to this conclusion, I part ways with several other originalists. Some originalists argue that the key to uncovering the 14th Amendment's meaning lies with its legislative history, figuring out what Jacob Howard or John Bingham said. Scholars in favor of incorporation of the Bill of Rights against the states in particular often rely on the legislative histories. Others say the key is the changed public understanding of terms like due process, influenced by abolitionist constitutionalism. I think this is what Evan is going to focus on. Many of these scholars claim, for example, that terms like due process did not have a substantive component. Let's put it this way. If it didn't have a substantive component prior to the 19th century, it did after, as a result of the abolitionist constitutional influence, right? The changed understanding from the abolitionist thinkers. Still other originalist scholars, at least if we think Jack Balkin is an originalist, argue that the open-ended nature of the text of the 14th Amendment authorizes judges to sort of impose modern-day values on the text. And finally, still others, like Justice Scalia, at least some of the time, agreed that the text was somewhat open-ended, and so we must look to tradition and historical practice, or one might even say the original expected application of the text. Justice Scalia, by the way, wasn't perfectly consistent about this, but he did take that approach occasionally. My approach is different. My approach is different. My claim is that the 14th Amendment is written in the language of the law. Each of the key concepts, due process of law, the protection of the laws, and the privileges and immunities of citizenship, I argue, has a rich antebellum legal history, and each has a quite specific legal meaning. Moreover, my claim is that these specific legal concepts directly solve the principal problems that the framers of the 14th Amendment confronted, namely the comity rights of free Blacks, the widespread private violence, and then, of course, the abridgment of the rights of the newly freed people in the Black codes. Okay, obviously, I can't go through all of that in 20 minutes. So what I want to do for the remainder of my time is to make an argument about the meaning of the Privileges or Immunities Clause of the 14th Amendment, the provision that says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. There has been a lot of originalist scholarship on the Privileges or Immunities Clause. You may have heard that the clause incorporates the Bill of Rights against the states. This is Kurt Lash's view in his book on the Privileges or Immunities Clause. It's Akilah Marr's view. It's Michael Kent Curtis's view. It's Justice Thomas's view. And I think it's Randy Barnett's view. Indeed, it's fair to say that today incorporation of the Bill of Rights against the states is widely regarded by originalists as consistent with the original meaning of the Privileges or Immunities Clause. You may have also heard of an alternative version of the clause's meaning, which I think is Evan's view, though he'll let us know. And other, this view is also associated with other sort of proponents of economic liberty and civil libertarians, right? They would argue that not only does the Privileges or Immunities Clause incorporate the Bill of Rights, but it also guarantees other fundamental economic liberties like contract and property rights too. So putting this together, thus far, the debate within the originalist community, within the originalist literature about the Privileges or Immunities Clause has largely been between two positions. Does the Privileges or Immunities Clause only incorporate the Bill of Rights, or does it also protect other unwritten fundamental rights against state action? Well, I would like to suggest that according to the best reading of the Privileges or Immunities Clause, it probably does neither. I want to suggest that the clause does not guarantee any fundamental rights against state action. Rather, the clause is an equality provision with respect to civil rights under state law. This means that a state could, for example, cabin the right to contract as much as it wants, and it could, I suppose, prohibit handguns. But what a state can't do is prohibit only Black citizens from owning guns or only Asian citizens from entering into contracts, right, longer than 10 hours a day. So the evidence I want to lay out goes as follows, and I'll try to be brief. First, the Privileges or Immunities Clause was intended to constitutionalize the Civil Rights Act of 1866. I don't think that's really disputed today among originalists. And my claim is only the anti-discrimination reading of the clause succeeds in that task. The Equal Protection Clause doesn't do the job. Okay, second, this will be a shorter point, the very historical problems that professors Michael Kent Curtis and Akilah Marr and others have written about in support of the incorporation thesis, you know, the general abridgment of civil liberties and particularly free speech and press rights in the antebellum period, and after the period, I guess, as well. These problems would actually be solved by the anti-discrimination reading of the clause. So let's start first with the Civil Rights Act of 1866. At least 18 members of the 39th Congress explicitly connected the 14th Amendment with the purpose of constitutionalizing this act. Compare that, by the way, to only 2 who said anything about what today would be understood as incorporation, and even then, really only 1 of them said anything about incorporation. Well, why does this matter? What was the aim of the Civil Rights Act? Well, its aim was to eliminate the Black codes that had arisen in the South after abolition, right? And it was in these Black codes, the Southern state governments systematically denied their Black citizens the same rights that were enjoyed by white citizens. So the newly freed men and women couldn't own real property. They couldn't rent in some states except under the supervision of town authorities. Black citizens were required to enter into contracts, often agricultural contracts, right, by a certain day in January. They couldn't testify in courts to the same extent whites could, and they couldn't own firearms or daggers, and they couldn't assemble. Okay, so the Civil Rights Act of 1866 declared, and I quote, here it is, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. And such citizens of every race and color, again, such citizens, what citizens of the United States, shall have the same right in every state to make and enforce contracts, to sue, be parties, give evidence, inherit, purchase, lease, sell, hold, and convey real and personal property as is enjoyed by white citizens. Know what the Civil Rights Act does and doesn't do. It doesn't guarantee any rights at all. It doesn't define any of the rights it lists. It instead guarantees only that whatever civil right a state happens to accord its white citizens, it must also give its Black and other citizens. Note also the terminology. Kurt Lash has written that the privileges or immunities of citizens of the United States, right? Citizens of the United States was a term of art referencing the Bill of Rights and other enumerated federal constitutional rights. But note how it's used, note how that phrase is used in the Civil Rights Act. The act declares anyone born in the United States to be a citizen of the United States, and then says such citizens, that is, such citizens of the United States, are entitled to equality with respect to the provision of civil rights defined by state law. Consider also Andrew Johnson's veto message. The bill, he said, contains an enumeration of the rights to be enjoyed by those classes so made citizens. Again, citizens of the United States. And he mentions the whole host of state-defined privileges and immunities. Well, the natural response to this is, doesn't the Equal Protection Clause do the trick? Isn't the Equal Protection Clause what requires equality, right? In privileges and immunities and civil rights and the like. Alas, the Equal Protection, and here I think Evan and I agree, I think. The Equal Protection Clause does not mean what we've all been led to believe. We've all been led to believe that equal protection of the laws means equality generally. But in fact, it means something much more specific. Equality with respect to the protection of the laws. What was the protection of the laws? Well, in short, the protection of the laws was the flip side of due process of law. Due process of law provided the mechanism by which someone could be deprived of life, liberty, or property only by the government, okay? Only by the government, and only according to established laws and known procedures, okay? From this definition, by the way, I can't resist pointing this out, you might see that there's no substantive component to due process of law, or so I argue. I think here Evan might disagree with me. Okay, well, the protection of laws is the flip side of this procedural understanding of due process of law. It is the protection the law must accord to your enjoyment of and your exercise of life, liberty, and property, right, against private interference. Against private interference. So this means that the government must actually protect you, for example, by providing police services, and it must intervene against mobs, right? It means the government must give you redress in court so you can sue for trespass, battery, or what have you. And I'll just mention Blackstone and John Marshall, right? When in Blackstone's commentary, he says that the remedial part of the law, right, the method of recovering and asserting rights when wrongfully withheld or invaded is what we mean when we speak of the protection of the laws, right? That's remedial rights, okay? And in Marbury v. Madison, Marshall wrote, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. So the Equal Protection Clause, or I should say, the Equal Protection of the Laws Clause, doesn't constitutionalize the Civil Rights Act of 1866 because the protection of the laws says nothing at all about the content of liberty or property rights. It merely means that whatever liberty and property rights one happens to have, according to law, which they could be terribly unequal, right? The state must nevertheless give that person equal protection of the laws so that she or he may enjoy and exercise those liberty and property rights. So this takes me to my shorter point, responding to the historical analyses of Professors Akhil Amar and Michael Kent Curtis and others. Yes, it is true. There was a tremendous problem with the abridgment of civil liberties in the antebellum and also postbellum period. The South was repeatedly denying First Amendment rights to abolitionists. This greatly concerned the Republican Party. And of course, the South repeatedly denied Second Amendment rights to the newly freed men in the Black Codes. But the anti-discrimination reading of the Privileges or Immunities Clause solves these very problems. After all, the problem wasn't that the Southern governments didn't have First Amendment protections. They all did. Each and every Southern state constitution had a First Amendment equivalent. So we don't need incorporation. The problem, rather, was that the states were selectively denying this right to specific populations, to Blacks and to abolitionists. The same goes for the Second Amendment. The problem wasn't that the state governments were denying Second Amendment rights writ large. The problem was they were denying them to Blacks only. Consider the following statement made by the famous abolitionist Elijah Lovejoy, merely days before an anti-abolitionist mob destroyed his fourth printing press and murdered him. He was lynched, he was murdered. The question for Lovejoy wasn't whether he has the right to free speech and press. No one denied that. The question was different. Here's what he said. The question to be decided, said Lovejoy, is whether I shall be protected in the exercise and enjoyment of those rights. That is the question, sir. Whether my property shall be protected, whether I shall be suffered to go home to my family at night without being assailed and threatened with tar and feathers and assassination. So an anti-discrimination reading of the Privileges or Immunities Clause would solve the problem of the abridgment of civil rights, because state constitutional rights are privileges and immunities of citizenship. And so the South and the northern states too, by the way, must now provide those privileges and immunities equally and not selectively. And the Equal Protection of the Laws Clause would now require the states to provide legal protection for the exercise of these known rights on equal terms to all. You simply don't need incorporation. You don't need a fundamental rights reading of the Privileges or Immunities Clause to solve this critical historical problem. So let me conclude with some musings on modern day, right? So it seems to me that the best reading of the clause is that it neither incorporates the Bill of Rights nor gets us to unenumerated rights or economic substantive due process as in Lochner, okay? That was the, of course, infamous case, famous, infamous, depending how you look at it, in which the Supreme Court struck down a New York state law limiting the number of hours bakers could work in a day, right? They struck it down as arbitrary and unreasonable. I don't think we get Lochner. I think Lochner was wrongly decided. You don't guarantee fundamental rights, right? The Privileges or Immunities Clause only requires that whatever privileges and immunities a state accords some of its citizens, it must accord all of its similarly situated citizens free from arbitrary discrimination. So this means that we may not get Lochner, but I don't think that means Slaughterhouse was right? In Slaughterhouse, that case involved a monopoly given to one favored group of butchers, right? In New Orleans, extreme economic favoritism or protectionism may well state a claim because it would be effectively giving one set of citizens more rights than another. But the point is the clause doesn't prohibit unreasonable regulations. It prohibits only unreasonable discriminations. Okay, what about Brown v. Board and Obergefell v. Hodges? School desegregation and gay marriage. Well, I argue Brown is an easy case under the anti-discrimination reading of the Privileges or Immunities Clause. Was public education a civil right, a privilege of state citizenship under state law in 1955? Of course it was. Thus, if Kansas guarantees this privilege to white citizens, it must guarantee it on equal terms to Black citizens. And we all know that the separate but equal wasn't, its intent was never to keep Blacks equal, right? It's as Justice Harlan said in Plessy v. Ferguson, these laws aren't for the benefit of it's not to keep, the white man away from the Black man, but to keep the Black man away from the white, right? We all know what the purpose was, and it was discriminatory, okay? Now, Obergefell finally is a bit harder. Not a foolproof case, but at least it's plausible. What if the court had written a short 2-page opinion along the following lines, right? The Privileges or Immunities Clause is an anti-discrimination provision with respect to state-defined civil rights, right? Privileges and immunities under state law. Marriage is a privilege, such a privilege, and it comes with a bundle of other valuable privileges. And once it's recognized that being gay is not a choice, and it's not reasonable to ask gays to marry individuals of the opposite sex in order to obtain such privileges, limiting marriage to a union of a man and a woman abridges the privileges and immunities of gay citizens, right? It gives one set of privileges to heterosexuals that it denies arbitrarily to gays. Look, not a foolproof case, right? Not a foolproof case. Of course, the state can always come back and say, well, it's a reasonable discrimination and so on, right? But at least this argument is plausible. At least if the Supreme Court had decided Obergefell this way, wouldn't we have all gotten the feeling that at least the court was making an honest attempt at doing law? So my claim in short and in conclusion is that the anti-discrimination reading of the Privileges or Immunities Clause is the only reading that gets us Brown v. Board. It's the only reading that makes at least a plausible case for Obergefell. As should now be clear, the protection of the laws doesn't get us there. That has nothing to do with defining rights. Neither case had anything to do with due process. And at least Obergefell would be tough to sustain under any rigorous version of substantive due process. And obviously incorporation doesn't do anything for those cases either. So not only is the anti-discrimination reading the best reading of the clause, maybe it's the reading we should like the best. And with that, I will eagerly anticipate Evan's comment. Thanks for your attention.
Well, thank you, Elon, for that terrific presentation, and thank you to the Texas Federalist Society and to Seth for organizing this. I know this is supposed to be a debate, but I want to begin by really summarizing what I take to be the two primary accomplishments of Elon's excellent book. First, his book lives up to its title. That is rare. There are tremendous financial and reputational incentives for academic authors and publishers to overpromise and underdeliver, and Elon's title promises a lot, introducing arguably the most pivotal amendment in our nation's history, an amendment that's central to our constitutional culture, and it's the constant object of constitutional litigation today. That's no small thing. Not since Raoul Berger's Government by Judiciary has anyone published a book on the original meaning of the entirety of Section 1 of the 14th Amendment. And Elon's book is way, way, way better than Berger's. It is concise, comprehensive, and compelling. If you're here for this talk, you really don't have an excuse not to read it, so read it. Second, Elon's book does more than live up to its title. It's more than an introduction. It provides a spellbinding legal history of the 14th Amendment in the service of an ably argued case for a particular understanding of the original meaning of Section 1. So Elon takes us from Magna Carta through the Petition of Right to Blackstone's commentaries and also to antebellum state and federal cases in some 200 pages, including footnotes. And he argues that the 14th Amendment was carefully crafted in the language of the law, as he puts it, to address the concrete needs of formerly enslaved people, to secure even to non-citizens life, liberty, and property rights and protection against both public and private violence, the due process of law, and the equal protection of laws. I learned a lot from this history, particularly about due process of law. Elon has uncovered and established the importance of the history of judicial review of corporate bylaws, of which I was largely ignorant, and I probably should have known something about prior to publishing an article about due process before Elon did. I also agree with Elon about a lot. Our views of the Equal Protection Clause are quite similar. And I emphatically agree with him that any plausible theory of the meaning of the Privileges or Immunities Clause needs to account for the fact that the clause was advertised to the ratifying public as a means of securing the constitutionality of the Civil Rights Act of 1866, and the theories that hold that the clause just incorporates the Bill of Rights against the states can't do that effectively. And yet, for all of that, Elon and I see some things very differently. His book does what it says it'll do. It introduces. But the positive case he makes for his understanding of Section 1 strikes me as incomplete. I suspect that this is a function of some subtle but important methodological disagreements between Elon and myself. Disagreements that are probably easiest to perceive by focusing on his account of the Privileges or Immunities Clause. Elon is so focused on legal history that I think he neglects how social movement constitutionalism led the anti-slavery forces that shaped the clause, the Privileges or Immunities Clause, and indeed the entire 14th Amendment, to converge upon the proposition that certain fundamental rights needed to be secured, not just against discrimination, as Elon claims, but absolutely. By lasering in on legal history, the book misses out on the contribution of that outside the court's constitutionalism to original meaning. Now, it is demonstrable that by the 1860s, leading Republicans held views about the meaning of the privileges and immunities of citizenship that were legally unorthodox. The orthodox reading of the Privileges and Immunities Clause of Article 4, on which there is general agreement that the language of the Privileges or Immunities Clause, the 14th Amendment, was based, throughout the antebellum period, held that the clause was a comity clause. That is, it only protected traveling citizens against parochial discrimination. And yet Republicans repeatedly, publicly insisted that it did more than that, much more than that. Here's what a resolution adopted by the Republican National Convention in 1860 said. I'm quoting here. Resolved, that we deeply sympathize with those men who have been driven, some from their native states and others from the states of their adoption, and are now exiled from their homes on account of their opinions. And we hold the Democratic Party responsible for this gross violation of that clause of the Constitution which declares that the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, end quote. Driven from their native states and from the states of their adoption on account of their opinions. That's not a complaint about violations of interstate comity. That is a complaint about the harassment, censorship, and outright murder of anti-slavery advocates, abolitionists and Republicans, whites and blacks, men and women, within their own states. It had long since become clear to Republicans that mere comity was not enough to suit their moral or political purposes, however entrenched it was in antebellum law. Southern states were enforcing bans on anti-slavery speech, equally against their own citizens and out-of-staters. If we go with legal meaning, like Elon says we should, we can't explain statements like this, of which there are many. Now, that doesn't mean he's wrong about anti-discrimination, but to make his anti-discrimination case work, he needs to go beyond legal meaning. Because if we stick to legal meaning, we're stuck with something Republicans clearly didn't believe or say they believed about the privileges and immunities of citizenship. So let's consider that resolution on its own terms without regard to its legal orthodoxy or lack thereof. Elon argues that it, and other similar statements, should be coded in favor of an anti-discrimination reading of privileges and immunities. Every citizen gets equal civil rights. If a state gives the right to speak freely, other similarly situated citizens must have the right to speak freely. But nothing really stops a state from denying to everyone the right to speak freely, as Elon concedes. Now, he argues that Republicans weren't really concerned about that happening. No state would deny the right to speak freely to everyone. So there was no need to ratify an amendment to that effect. Well, the problem of multiple possible readings is a problem with which originalists have to deal, hard though it may be. Spend any time with the evidence that Elon canvasses and you'll see this right away. A significant proportion of the evidence bearing upon the 14th Amendment's original meaning consists in public statements to the effect that we need to secure XYZ rights. Such statements are often ambiguous as to how XYZ rights should be or will be secured. So suppose someone says the freedom of speech will be protected if the amendment is ratified. That may sound like pro-incorporation evidence. The freedom of speech needs to be protected, but maybe not. Suppose you think that the only danger to the freedom of speech consists in some but not others being allowed by states to exercise it. Then securing freedom of speech against discrimination will do the trick just as much as would securing freedom of speech absolutely. What's an originalist to do? Well, first you try your best to determine what the balance of the evidence favors. And I really don't think that the evidence that Elon examines is on his side. He says a couple of times that his theory is simple and neat. Indeed so. And all else equal, parsimonious theory should be preferred over unwieldy ones. But I don't think all else is equal. Rather, the theory that best explains the available empirical evidence is a fundamental rights theory, a theory that holds that enumerated personal rights associated with citizenship and any unenumerated rights associated with citizenship that are deeply rooted in the nation's history and traditions are protected, not just against discrimination, but substantively, though their exercise can be reasonably regulated. Now, we're not going to be able to systematically adjudicate this issue today, but I want to take issue with Elon's discussion of the most extensive pre-ratification commentary on the meaning of the 14th Amendment delivered by a leading Republican, and that is Michigan Senator Jacob Howard's speech introducing what would become Section 1 of the 14th Amendment to the Senate. In that speech, Howard identifies two categories of privileges or immunities of citizenship. The first category are the privileges and immunities spoken of in the second section of the 14th Amendment's 14th article of the Constitution. Howard reads a very lengthy passage from Justice Bushrod Washington's influential circuit court opinion in the 1823 case of Corfield v. Corrientes, in which Washington defines the privileges and immunities of protected by Article 4, Section 2 as rights, quote, which are in their nature fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign, unquote. Washington goes on, and Howard goes on to explain that privileges and immunities, quote, may be comprehended under the following general heads: protection by the government, the enjoyments of life and liberty, with the right to acquire and possess property of any kind, and to pursue and obtain happiness, and safety, unquote. He then lists several unenumerated rights that fall within these general heads, such as the right to travel and to be free from discriminatory taxation. After reading from Corfield, Howard identifies a second category of fundamental rights. Quote, to these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature. To these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution, unquote. Howard explains that the great object of the first section of this amendment is to, quote, restrain the power of the states and compel them at all times to respect these fundamental guarantees. Now, it sure seems to me, as it has seemed to most scholars of the 14th Amendment, that Howard is saying that states are going to be required to follow the first 8 amendments and other unenumerated rights that the Supreme Court would later refer to as deeply rooted in the nation's history and traditions. It doesn't seem like he's leaving room for states to deny those rights to everyone. Elon doesn't really dispute this, but he attaches little significance to it, describing it as a, quote, stray statement, unquote, from the legislative history. I respectfully dissent. This stray statement was published in leading newspapers and was sufficiently well known that the 14th Amendment was sometimes referred to simply as the Howard Amendment. We have no reason to doubt that Howard meant and was understood to mean what he in fact said, and it was consistent with what he said in other contexts about privileges and immunities throughout his political life. So I submit that Howard's speech carries more weight than Elon gives it. And then there's the evidence that Elon doesn't examine. Perhaps because he is so focused on legal meaning, he does not pay sufficient attention to voices that contributed to the anti-slavery thought that shaped the 14th Amendment, despite being politically and educationally disenfranchised. In particular, I'm thinking of Black voices. You would not know from Elon's book that there was an entire movement spanning decades prior to the 14th Amendment's ratification that brought together free Blacks in conventions, advertised as colored conventions, wherein they debated and strategized to abolish slavery and establish Black citizenship. Nor would you know that what they said about citizenship offers further evidence of a legally unorthodox public understanding of the privileges and immunities of citizenship that went well beyond comedy and anti-discrimination. In denouncing discriminatory state laws, Blacks repeatedly referred to the privileges and immunities of citizenship and specifically cited the Privileges and Immunities Clause of Article 4. They did so not only when complaining about the laws of other states to which they might travel, but when criticizing the laws of their own states. They did so in some of the freest states in the North. They spoke of rights to speech, religion, the press, education, and arms in terms that made it unthinkable that they would accept as consistent with citizenship the wholesale deprivation of any of them. For instance, an 1865 South Carolina convention demanded access to, quote, the 3 great agents of civil society, the school, the pulpit, the press, unquote. The clear implication is that civil society can't flourish without those rights. Now, to be clear, I'm not saying that we should incorporate voices that were marginalized in the past into our interpretation of the Constitution today in order to bolster the Constitution's legitimacy today. I'm an originalist. Original meaning is what it is, however unjust the process through which it was produced. But these voices reached anti-slavery Republicans and gave expression to a public understanding of what it meant to be a citizen of the United States. They are probative of what the privileges and immunities of citizenship meant to those for whose benefit the 14th Amendment was primarily, though not exclusively, designed. They are certainly more probative of original meaning than anything that Andrew Johnson said about the constitutionality of the Civil Rights Act of 1866, which Elon highlights for reasons that remain rather mysterious to me. Justice and fidelity to original meaning point in the same direction and call for more attention to the colored conventions than Elon provides. Now, in a pinch, when the evidence is roughly 50-50, I think that Elon and I do different things. We agree that the meaning of the words of the Constitution is shaped by the purposes for which they're used, and that it is coherent to attribute purposes to such deliberately designed entities as compasses, corporations, and constitutional provisions. We agree that it is the known purposes of constitutional provisions, those known to the ratifying public, that should be prioritized. But where Elon and I differ, perhaps, is that whereas purpose is only relevant to him insofar as it tells us what a word means, I find yet another use for it when one has thrown everything at a provision, including purpose, and one just can't tell whether it means X or Y. In effect, I count purpose twice. If the letter is unclear, go with the provision's known function, its spirit. The primary function of the Privileges or Immunities Clause is to establish, to place beyond legislative reach, a Republican citizenship that consists in the enjoyment of natural rights and civic equality, equality within the public sphere. You can have equality within the public sphere within anti-discrimination, but if a state wants to obliterate outright the natural rights of its citizens by denying to everyone civil rights that are necessary to secure natural rights, Elon's interpretation of the Privileges or Immunities Clause will not help you. I view that as less consistent with the original function of the Privileges or Immunities Clause than a fundamental rights theory. So even if I thought the evidence was 50-50, anti-discrimination versus fundamental rights, and I don't, I would favor a fundamental rights theory. I want to close by saying that notwithstanding this criticism, I've learned a lot from Elon, and you will too. We, and I mean this in the most expansive possible sense, needed a book like this. Again, this hasn't been done since Raoul Berger's Government by Judiciary, and that book was the product of hard, long nights in the Harvard Library, but that's about the most one can say in its favor. Today, it's basically a museum of mistakes to be avoided, and it doesn't account for decades of subsequent originalist work since its initial publication. Elon's book is the place to start if you want to learn about the 14th Amendment. It is an excellent place to start. But there's more to the story to be told.
Seth, I know we're running out of time. Can I say a few things?
No, please. I came back on to make sure that you knew that you had, at least 5 minutes. That sounds like much more than 5 minutes worth of content to rebut, but let's just start with 5.
Yeah, but first of all, thank you for the half generous remark. No, thank you for the very generous remarks and also the very constructive criticism. I think this is really just in the best spirit of originalist scholarship and scholarly inquiry generally. But I'm just not sure. I think you're overreading the evidence in your favor. And let me just summarize the evidence I think that's in my favor. And I'm going to summarize, right? On the one hand, my reading of the Privileges or Immunities Clause is consistent, and the other provisions, including due process, is consistent with centuries of antebellum legal meanings. And so if a court were to see it, that's the first thing they would go to. Not only is it consistent with the legal historical meanings of these terms, right? These resolve the problems. Deploying the historical terms, the legal history, the legal terms solves the problem. It actually solves every problem they were confronted. And third, it's consistent with what they thought they were doing, which was largely making an equality amendment. So that's on my side. And on Evan's side, you have a hodgepodge of admittedly unorthodox readings of these legal terms that weren't necessarily widely shared. And not only that, but these unorthodox readings, the statements that support them, could be read consistently, as Evan himself said in the talk, could be read often consistently with anti-discrimination, with an anti-discrimination reading. Right? Evan's concerned with, were they going, what were the word? I tried to write it down. He said, wholesale, what did you say? Wholesale destruction of rights or wholesale elimination of rights. Anyway, as like they wouldn't have countenanced that. But that wasn't on the table. That was on nobody's intellectual horizon because whites weren't going to give up these rights. In the 19th century, these were divine, sacred, inalienable rights. Free speech, press, assembly, petition, the right to bear arms. Whites weren't going to deny these rights to themselves. That was not on the table. The issue was discrimination, right? And the Privileges or Immunities, the equality reading sort of solves that problem. And I think the same, by the way, can be said of, I admit, the way we think of freedom of speech today, it sounds like an absolute individual right, the way you said it, but it can be read as anti-discrimination. And I mean, first of all, like quintessentially, what is First Amendment doctrine? Viewpoint discrimination, content-based discrimination. I mean, so it's kind of discrimination, but listen to what one Union general said about why he didn't want members of the South represented in Congress. The Southern man knows that he can go to any part of the North and speak his sentiments freely. And this Union general did not want any part of the South represented in Congress until you and I can go and argue the principles of free government without fear of the knife or pistol or of being murdered by a mob. Right? So I just think it falls flat to say, well, whites were denied the right equally to speak abolitionist sentiments. It's like, nobody in the South wanted to speak abolitionist sentiments. No one in the South wanted to do that. So it just seems weird to say, well, they were treated equally. No, they weren't. Like it's the wrong baseline. It's the wrong denominator. The question is, could the people in the South speak their mind freely? Turns out, yes, they could. Yes, they could. It was only a discrimination against particular people with particular sentiments. And that's consistent, I think, with the anti-discrimination reading. I admit Evan's reading is possible. I completely admit Evan's readings is possible. And I am not claiming history is clean and in all one direction. I do think it's messy. I do think there's contradictory evidence. Okay. But I didn't even mention Jacob Howard, but I want to take time for questions. I'll leave you because Evan ended on the colored conventions. I admit that I don't give as much space to Black voices as I should. But I do quote the Alabama Colored Convention of 1867. And here's what they said. Page 109 for those following at home. Only $20, by the way, online. As there seems to be considerable difference of opinion concerning the legal rights of the colored man, it will not be amiss to say that we claim exactly the same rights, privileges, and immunities as are enjoyed by white men. We ask nothing more and will be content with nothing less. Color can no longer be pleaded for the purpose of curtailing privileges, and every public right, privilege, and immunity is enjoyable by every individual member of the public. This is the touchstone that determines all these points. So long as a park or a street is a public park or street, the entire public has the right to use it. So long as a car or a steamboat is a public conveyance, it must carry all who come to it and serve all alike who pay alike. The law no longer knows white nor black, but simply men. And consequently, we are entitled to ride in public conveyances. And it goes on a bit. That sounds like an equality argument to me. Anyway, I'll stop there. There's much more to say, by the way, and there's lots of good evidence on Evan's side. But I just think it's actually cleaner. I think there's more evidence on the anti-discrimination side. I see we have some questions in the chat. Oh my gosh!
Let's just get to the questions. I'm willing to let it stand there.
Cool. Okay. Absolutely. So we'll go to questions. First one in, I won't go in exact chronological order because I think the first question is actually best suited to be our last, like how we'll end out. I'll start with Christopher Green's question for you, Ilan. Could a state say that no one but a police officer could have a gun? Would that be an unconstitutionally unequal privilege of citizenship?
I have no idea. I have to think about it. Okay. Chris Green, you stopped me. Chris Green is a professor at Ole Miss. If you are here and can you unmute him? What does he think the answer is? I'm actually curious. Can we do that? Can we unmute?
Mike, can you promote Professor?
I don't want to cause trouble, but
no, I mean, if
I'm curious what he thinks, if he can unmute somehow. I don't know.
Let me give it a shot. One sec.
Well, in the meantime, let's maybe go to another question while we figure that out. I didn't realize.
That was one.
Oh, there he is.
Oh, there we go. Okay.
Chris,
put him on blast.
What's your answer?
You can hear me?
We sure can.
Okay. I don't know. I mean, the different kinds of discrimination, given that it's a kind of a public versus private thing, I think you can make most of the free speech arguments. You can turn them into anti-discrimination. So see them as creedal discrimination. So people of one kind of political or religious creed can't have more rights than somebody else, which really lowers the stakes between them. But I wonder how far you can push the anti-discrimination thing. And I'm kind of mostly on your side, but I'm a little bit, I want to do a little more fancy dancing, trying to accommodate Howard as much as possible, as you know. So yeah. Anyway, I don't really know. I'd be inclined to think you can't, because there's a consensus of allowing people to have guns in the country, and then have one state saying that we're a gun-free zone. even if they didn't allow police officers, probably wouldn't be okay. But you can turn a lot of these free speech, especially things, into inequality cases. So anyway.
Yeah, and by the way, I commend to everyone Chris Green's book. Though Chris, it is very expensive. I don't know if you're aware. You're probably aware.
Academic market.
No, Cambridge. I got to get your magic with these publishers. I've got to get myself a $20 book.
Yeah, Chris Green's book I think is like $110. But
the surplus value there is huge.
Yeah, true. But he goes further with the anti-discrimination argument and says, or the privileges or immunities argument, right? And says that it prohibits sort of outlier states when it comes to certain fundamental rights. So Chris, correct me if I'm wrong, but I think your view is Griswold v. Connecticut can be rightly decided if Connecticut was an outlier state with respect to contraception in marriage. Is
right. So Second Justice Harlan's rationale saying, Connecticut's completely by themselves in this. That and I would pitch it as a kind of inequality, but it's an inequality among citizens of the United States, whether they be in the same or in different states. And that seems to me like what Justice Field is saying. It's at least that's how I read him. He seems like he doesn't have a hard edge that it's only anti-discrimination. But it's the common privileges of citizens of the United States, wherever they be. And I think you can make an anti-outlier thing. But I like Howard, and I want him to. He makes so much more sense than other people in a lot of other debates that I really want to accommodate that evidence as much as I possibly can.
Chris and Evan, what do you think about this theory of Howard's speech mentioning the first 8 amendments? I mean, there was a theory, and Akhil Amar talks about this in favor of the incorporation thesis, but I'm not sure it actually covers it, where state judges talked about not how the Bill of Rights was incorporated against the states in the antebellum period, but the Bill of Rights was declarative. It was declarative of natural rights that were independently binding on the states. And the Bill of Rights was just evidence of that. Why can't the reference to the 8 amendments be a reference to these declaratory natural rights of which the states mostly protected? Almost all the states protected some variant of these rights. And then if under state law, one of the related rights, whether it's speech or trials or what have you, or guns, why can't Jacob Howard's speech be sort of understood as a reference to that, maybe as the declaratory theory? And that would accept that the states protected these rights as well, but they were allowed to define the content of those rights for themselves.
I think that's plausible. My overarching category for what a privilege or immunity of U.S. citizenship is a right deeply rooted in the nation's history and tradition. And the personal rights that are enumerated in the Bill of Rights, their enumeration is evidence, strong evidence in favor of them being among those rights. Strong enough to the point, I think, of being presumptively, unless you can demonstrate that a particular right was specifically excluded. And I don't think that there's evidence to that effect. But the meta category is deeply rooted and fundamental and connected with either natural rights or civic equality. The Bill of Rights are not an independent, different kind of rights. And so I think that reading of Howard is plausible.
No, that's interesting. Well, we should go to another question, but if Chris Green wants to stay on, I mean, you're just getting more bang for your buck.
Oh, sure. Yeah, I feel like I should withdraw. I feel like I should.
It's up to you.
I feel like I should withdraw my question for Evan, given what he just said, that it's not that the Bill of Rights stuff is not an independent question, but it's really just the Corfield standard, and then you apply it, and it gives you some of the things in the Bill of Rights. That seems like better reading.
The Corfield standard. The Corfield standard is the meta category.
Oh, good. Well, that's good that you talked Randy out of the kind of more like Bill of Rights by definition stuff that he said earlier.
Yeah.
Good.
So that knocks me into things too.
Cool. Well, Austin Nelson has a pair of questions, one for each of you. I'll start with the one for you, Ilan. What do you make of the Lautnerite scholarship on the 14th Amendment? In particular, Howard Gilman's view that liberty of contract was rooted in a long American tradition of opposition to class legislation. And second, David Bernstein's view that liberty of contract was rooted in the Republican free labor ideology.
So I have a crisp 3 or 4 pages in the book on the anti-caste legislation view. And the thing that's remarkable about this, I don't know if it's just like someone hasn't done the work, but it is true. It is true that there is a lot of language in many antebellum cases in which state courts said that due process of law prohibits partial laws. Due process of law requires general laws. But in every case, and there are dozens of these with 2 exceptions that I found, both from Tennessee, every state court saying due process of law prohibited partial laws, those partial laws that were at issue in those cases involved abrogating judicial procedures for a particular class of persons, right? Often in cases that were pending, or just abrogated things like trial by jury for certain classes of claims. All but 2 of the cases are consistent with the traditional procedural understanding of due process of law, even though they do use this language, often partial legislation. So a lot of people agree with the Gilman thesis, and as I think David Bernstein does, by the way. Ryan Williams has a lot of this in his paper on due process, the one and only substantive due process clause, which is clever. He has the best article titles, by the way. He's just a very, very good writer. But I just think it's wrong. They're almost all consistent. As for, again, the free labor ideology, I think it's similar, to the abolitionist constitutionalism, ideology. So let me start with that. Randy is elsewhere, focused on the abolitionist thinkers reimagine due process of law to prohibit slavery. Okay, and this requires a substantive component to due process of law. But when you look at what they all say, it's all consistent with the procedural due process. It's all of it. They say things like, has a single slave in the District of Columbia been deprived of his liberty by a judgment of his peers? They say things like that. Now, maybe it's a stretch to apply due process of law for the procedural one to invalidate slavery, right? Because if that argument's true, if that's correct, that means the founders inadvertently abolished slavery in all federal territories in the District of Columbia in 1791 when they enacted the Due Process Clause. Not crazy, by the way, but maybe it's a stretch. But the point is they were citing traditional statements of due process, even though they might have been misapplying it, or maybe not misapplying it. But so I think a lot of it is consistent with the procedural understanding of due process. And also, by the way, free labor ideology, police powers, all of that was heavily involved in municipal corporations cases and questions of delegated power. A lot of those things don't have to do with the state legislatures themselves.
Awesome. So now a question for you, Evan. What do you make of the pro-slaughterhouse argument? In a recent Virginia Law Review article, which I'm going to go ahead and post there, Cynthia Nicoletti argues that the slaughterhouse cases represented a welcome return to the ordinary operation of law in the United States. Given the ambiguity of the 14th Amendment's text, she contends that the slaughterhouse court was correct to read the amendment narrowly in light of the background principle of federalism, which the Reconstruction Congress did not explicitly repudiate.
So I haven't read that article yet. I am suspicious of it for the same reason that I am suspicious of the raft of slaughterhouse revisionism that has emerged in recent years, which consists largely in arguing that the case was probably rightly decided and eliding what the court actually said about the 14th Amendment, which basically nobody defends at this point. You get this idiosyncratic list of rights associated with the federal government, like the right to protection while traveling on the high seas and the right to travel to seats of government, none of which was of any evident interest to formerly enslaved people or their allies. If slaughterhouse can be defended on the grounds that under the circumstances that the Reconstruction legislature was facing, and by way of dealing with a very pressing public health crisis, it was best to give this Reconstruction government the space to resolve it rather than insisting upon something that could reasonably be called laissez-faire, which is what you get in Justice Field's opinion. Fine, but the theory that animated slaughterhouse, this bizarre group of rights, plus this intuition that really no fundamental changes could have been possibly contemplated by this amendment that followed a bloody civil war. I find that very implausible. But I'll read the article. I'll take a look.
Well, maybe we can do this again sometime and you can give us your thoughts on it. So we have a couple more good questions. I'm just going to give us this one last one to close out because we're running up against an hour and I want to give you all your evening back. This is a question, at least it's styled as a question for Professor Werman, but I'd be interested to hear Professor Bernick's opinion on it too. He says, I have your book. It's very persuasive and one of the most compelling and original, no pun intended, ideas and originalist scholarship in a long time, a must read. But my question is, if you're right, what now? Incorporation is basically complete. Do you think the court should unwind incorporation? Do we have to do that to get all the other benefits of the privileges or immunities clause?
By the way, in brief response to the other question from Mike Rosen on the citizenship clause, I think it applies to all persons born in the United States, right? And that includes people who are here visiting, just passing through, and if that's not true, sorry, I know I'm not answering the question. It's just they're both interesting, and I know we've got like just another minute. If birthright citizenship, okay, is it correct? That means some people risk being born citizens of no country at all. Maybe we don't care, that much about it, but I'm skeptical that that's likely. And the other thing to keep in mind, again, as conservatives, okay, as FedSoc types, why are we trying to push the words of the Constitution to cover a political situation that it is within the power of Congress to solve? If Congress wanted to stop the problem of people becoming citizens in this country, by having their parents illegally come here and having babies, Congress can solve that problem. Congress can build a border wall. Congress can increase security at the border. And the fact that it chooses not to, I don't think means we as conservatives should contort the text to achieve that political result that we would rather have, but haven't won, right, in the political process. Okay, back to the judicial process. What should courts do about my reading of if I'm right about incorporation? One possibility is incorporation is within the range of plausible meanings, right? Such that it has been liquidated with time. It has been settled. The problem with that approach, of course, is it was liquidated under the wrong clause. It was liquidated under substantive due process, which I think is wrong. So can you liquidate a practice? Can you settle a question if it's been incorrectly settled under the wrong clause, even though it might be settled under a different clause? I don't know, but someone should write an article exploring that question. And the other thing I'll say, so two more things. One is a lot of these rights might be incorporated anyway by virtue of due process because there are procedural rights. There are actually a lot of procedural rights. And if you look at Murray's lessee from 1856, 1855, I don't know. What is due process of law? Well, the first thing is the rights listed in the Constitution that deal with process, like criminal trials. So maybe those are incorporated, and that's most of them, right? And as to the ones that aren't incorporated, would the world be so terrible? Would the world be so terrible if states can experiment with rights? California can get rid of guns and free speech for corporations, and Texas can get rid of Miranda warnings and suppression of evidence. I mean, it's not obvious to me like how this cuts, right? Maybe we want more federalism and experimentation with rights. Especially the liberals should like this too, in a world where they're concerned that the Supreme Court is weaponizing the First Amendment or whatever that means. I'm actually not sure, but that's what they say. So they should be in favor of my approach.
Just immediately following up on that, Elon, what does your approach say if a state says we want to ban hate speech, nobody can engage in hate speech? I think about everything else. We just not hate speech.
Right. So I think it's the same problem that as the abolitionists face. I think in some respects, the First Amendment might be partially incorporated anyway, to the extent that the First Amendment itself is a non-discrimination provision, right? If you're denying certain people the right to speak certain thoughts, this cradle discrimination, as Chris Green said, then that's giving some speakers more rights than others, right? It's just silly to say, well, we're allowing, everyone who wants to say good things about the government to speak. So everyone can say equally good things about the government and equally can't say bad things about the government. I mean, that's actually still discrimination, right? You're just favoring certain people's speech over other people's speech, and you're making it look like it's neutral when it's in fact not, right? So I think First Amendment is quintessentially about anti-discrimination. And so maybe I'm giving away the game by saying it's mostly incorporated anyway, you know? So maybe I just gave away my hand there. I don't know. I have to think about that.
Kind of a reverse incorporation, you might say.
Yeah, that's right.
Cool. Well, I think we'll leave it there. I'm deeply grateful to you both for joining, and then for Professor Green for making a guest appearance. Why have 2 originalists when you could have 3? It's very
That's
cool.
right.
Yeah, invite me out sometime. That'd be great.
That sounds good. That sounds good. We'll have to do that.
Well, Chris, you need a book that's much cheaper before they can bring you out to speak and hawk.
Yeah, my book is going to be the whole story from Magna Carta up to Obergefell. So it's going to be like 800 pages long, but I want it to be cheaper than $10. That's my goal.
Chris, you have to write books that people will write and the people will read. And to defend earlier, Evan said it's 200 pages with the endnotes. He should have, of course, said it's 144 pages without the endnotes. So really no excuse. So it's
a grievous omission on my part, Elon.
All right, sorry, Seth. Thank you.
No, it's totally fine.
Great, Seth. Thanks for putting this together. I really enjoyed the discussion. And yeah, thanks to everybody who came.
Yeah, me as well. Thanks so very much, Seth.
Thanks to the members who came. Mike, the man behind the scenes, has dropped the information for our next debate, which will be next Thursday at this time between Professor Vladeck and Professor Will Bode from the University of Chicago. They're actually pretty good friends, so it should be a pretty good debate on both collegial grounds and on substance grounds. And if you're interested in attending FedSoc Friday, please text Belinda Schwertner. She'll be hosting tomorrow at her apartment. So that's all the announcements for now. Y'all have a good night.
Thanks, everyone.